A federal judge in New York has denied the Department of Justice's request to unseal grand jury material from Jeffrey Epstein's criminal case. It comes as the DOJ is now 2 days away from handing over records to Congress related to Epstein's sex trafficking investigation as part of a subpoena by the House Oversight Committee. Washington, D.C. Bureau Managing Editor Catherine Faulders has more.
Alex, we're just learning that third federal judge in New York has denied the Department of Justice request to unseal additional grand jury materials from Jeffrey Epstein's case. Remember, DOJ had asked judges in both Florida and New York to unseal grand jury materials that were related to his case, but also admitted in court filings that they didn't believe any of those materials would necessarily be new. So we do know that previously 2 federal judges denied that request. So this is the latest federal judge to deny this request.
Hey everybody, Adam here, full energy, no filter. Headlines exploded with claims of bombshell revelations about Trump and Epstein, but the reality is more complicated. The dramatic framing isn't quite aligned with what's actually happening in the legal system. The reality of the situation is far more nuanced than the clickbait suggests, and understanding that reality requires wading through a thicket of legal technicalities, judicial rulings, and political calculations that most coverage completely ignores. A federal judge has not, as of the latest court filings, unsealed Trump's own sealed testimony. There hasn't been some massive document dump that directly implicates him in criminal activity in the way that some content creators and social media personalities are suggesting. That doesn't mean there's no interesting and important legal story happening here, because there absolutely is. But the story that's actually unfolding is significantly different from the story being sold to generate views and clicks.
Breaking news in the Jeffrey Epstein controversy, a federal judge has just rejected the Trump administration's request to make grand jury documents in the case public. The judge had this to say in his ruling, quote, "The information contained in the Epstein grand jury transcripts pales in comparison to the Epstein investigation information and materials in the hand of the Department of Justice." We have CNN legal analyst Elliot Williams with us now. Quite a response from the judge there, Elliot.
It is quite a response, and he even uses the language I thought you were going to quote, Brianna, is where he says that the Justice Department has a substantial investigative trove in their possession that could be released to the public if the Justice Department so chose. There's nothing shocking about the judge denying a request to unseal grand jury materials because of how clear the law really is around the country about not making grand jury materials public. So this isn't a big shock here, certainly not the last we've heard of this.
The recent legal drama centers on failed efforts by both Trump and the Justice Department to unseal grand jury testimony and associated records from the Jeffrey Epstein cases. This is where things get genuinely complicated and strangely ironic. We're talking about related files containing hundreds of gigabytes of digital evidence, call logs, witness statements, and financial records that various parties have been fighting over in court for months. Multiple federal judges have denied requests to unseal Trump's sealed grand jury or deposition testimony related to the Epstein and Maxwell investigations, citing long-standing legal precedents that protect the secrecy of grand jury proceedings. The judges are saying there's a lack of what they call special circumstances that would be required to override those protections and release everything to the public, which is actually a pretty high legal bar to clear. Here's where it gets really interesting from a political strategy standpoint. The Department of Justice, at Trump's own direction, actually sought to release all pertinent grand jury testimony subject to court approval.
The Jeffrey Epstein saga stretches into another week. A New York federal judge denied today the Justice Department's motion to unseal grand jury testimony from the criminal cases against Epstein's convicted co-conspirator, Ghislaine Maxwell. The White House had promised to release materials related to the Epstein investigation after growing backlash from some in the president's MAGA base since the DOJ and FBI's determination last month that no additional files would be released. The judge saying the transcripts, quote, would not reveal new information of any consequence about Maxwell and Epstein's crimes. Maxwell is currently serving a 20-year federal prison sentence for sex trafficking and other offenses in connection with Jeffrey Epstein.
This prompted a nationwide media frenzy and bipartisan calls for full transparency about what Trump might have known or done related to Epstein. But then judges repeatedly ruled that the bulk of the transcripts and sealed exhibits do not reveal new information of any consequence. and their public release would only create what the judges called the illusion of new disclosures. Most of the substantive evidence is already public or was covered by previous investigations. So, unsealing these specific records wouldn't actually add much to what we already know about the Epstein case and Trump's peripheral involvement or lack thereof. Despite Trump and his allies initially resisting document releases in some cases, he eventually reversed course and voiced support for some selective transparency, which is a pretty significant political shift when you think about it. However, each judicial ruling made clear that unsealing these materials would not add new names, criminal accusations, or revelations beyond those already known to the public and to Congress. So, we're in this weird situation where Trump is actually pushing for transparency in some cases, but the courts are saying no because the legal standards for unsealing grand jury testimony are really strict, and they don't think the public interest justifies breaking those rules in this particular situation.
Federal judge is denying the Department of Justice's request to unseal grand jury testimony tied to Jeffrey Epstein. It's one of 3 requests made by the DOJ. The 2 others are still active. As ABC's Perry Russum reports, a Republican on Capitol Hill warns that if the full Epstein files are not released, this story could drag into next year's midterms.
A federal judge in Florida today denying the Department of Justice's request to unseal grand jury records tied to Jeffrey Epstein. The request is one of 3 made by the DOJ. Yesterday, the judge overseeing the request in New York says he plans to rule expeditiously.
I understand there are 2 other requests from the Department of Justice that are but I'll let this president speak to whether he wants to see an appeal.
It comes as Republican Senator Tom Tillis warns if the Epstein files are not released, this story could last through the midterms next year, when Republicans will be in a battle to keep the majority in the House and Senate. Tillis speaking with Axios.
If anybody thinks that this is going to go away because the House left a day early or something, it's got to be like those zombies in The Walking Dead. Every time you think you've killed it, another one's just going to come running out of the closet after you.
The only notable bad news for Trump has been persistent media speculation and court rebukes for the administration's sometimes disingenuous reasons for seeking the unsealing, plus ongoing congressional oversight of how the DOJ is handling these sensitive files. Judges have denied DOJ and Trump efforts to unseal grand jury transcripts, stating that the records contain material already in the public record and lack any first-hand information about criminal conduct by Trump or others beyond what we already knew about Epstein and Maxwell themselves. This happened repeatedly, with multiple judges basically saying the same thing over and over again. Judges have also sharply criticized the push to unseal these files as being more about diversion and creating illusion than actually adding new truth to public knowledge. They've warned that what they call the illusion of transparency would actually mislead the public into thinking they're getting new information, when really they're just getting repackaged versions of stuff that's already been reported and investigated extensively. The DOJ admitted the files contained over 300 gigabytes of evidence, but confirmed that no incriminating client list had emerged that would implicate Trump among known offenders, and most of the names mentioned were unverified hearsay that couldn't be substantiated through proper investigation. This is a really complex story that's being oversimplified in a lot of media coverage, and understanding what's actually happening requires digging into the legal mechanics of why these judges are refusing to unseal testimony and what the actual standards are for releasing grand jury materials. Grand jury secrecy is one of the most protected principles in American criminal law, and it exists for really good reasons that go beyond just protecting powerful people from embarrassment. The main purpose of keeping grand jury proceedings secret is to protect witnesses who testify before the grand jury from retaliation or public harassment, and to protect people who are investigated but not charged from having their reputations destroyed by unproven allegations. It also protects the integrity of ongoing investigations by preventing subjects from knowing exactly what evidence prosecutors have and what witnesses have said, which could allow them to obstruct justice or coordinate false stories. The legal standard for unsealing grand jury testimony requires what courts call particularized need in special circumstances, and that's a deliberately high bar that's meant to be hard to clear. You can't just say we think the public has a right to know, or this person is a public figure, so normal privacy rules shouldn't apply. You have to show that there's a specific compelling need for the testimony that outweighs all of those important interests in keeping grand jury proceedings secret. Courts also look at whether the information is available from other sources, because if you can get the same information without breaking grand jury secrecy, then that's what you're supposed to do. And in the Trump-Epstein situation, judges have repeatedly found that most of the relevant information is already publicly available through other means, like civil lawsuits, previous investigations, and media reporting. So there's no particularized need to unseal the grand jury material specifically. Now let's talk about the political dynamics here, because they're really fascinating and kind of counterintuitive when you first hear about them. Trump and his administration actually pushed for unsealing some of these Epstein-related files, which seems weird if you assume he has something to hide. But the strategy appears to be based on the calculation that the files don't actually contain anything seriously damaging to Trump, and that by pushing for transparency, he can claim he has nothing to hide and put pressure on political opponents who might be more vulnerable to Epstein-related revelations. It's a pretty bold political move when you think about it, because if the files did contain seriously incriminating information, then calling for their release would be incredibly stupid. The fact that Trump's team is willing to make that call suggests they're pretty confident about what's in there, or at least what's not in there, in terms of direct evidence of criminal wrongdoing. The judge's criticism of the unsealing efforts as creating an illusion of transparency is really interesting, because it gets at this broader problem with how we handle sensitive information in the age of social media and 24-hour news cycles. The judges are essentially saying that releasing these materials would give people the false impression that they're learning something new and important, when really they're just seeing the same information repackaged in a way that generates headlines and clicks, but doesn't actually advance public understanding. This is a legitimate concern because we've seen it happen before, where sealed documents get released, and media coverage makes it sound like there are shocking new revelations. But when you actually read the documents carefully, it's mostly stuff we already knew, presented in slightly different form. The 300 gigabytes of evidence that the DOJ has acknowledged possessing is a massive amount of digital material, and it includes things like call logs, flight records, financial transactions, and communications between Epstein and various associates. But as prosecutors have explained to the courts, most of this material is either not relevant to Trump specifically, or consists of unverified allegations that can't be proven and wouldn't be admissible in court even if they were relevant. This is a really important distinction that gets lost in a lot of media coverage, because people hear 300 gigabytes of evidence, and they assume that must mean there's tons of incriminating information. But actually, a lot of it is just routine record-keeping and background material that investigators collected in the course of their investigation, without it necessarily proving criminal conduct by anyone other than Epstein and Maxwell themselves. Trump's legal team and Pam Bondi have argued for releasing anything that's credible and can be verified, which sounds reasonable on its face. But court rulings have consistently maintained that strict secrecy rules must apply to uncorroborated sealed testimony and grand jury material. The judges are basically saying that just because an allegation exists in a document doesn't mean it's credible enough to release publicly and potentially destroy someone's reputation. This is where the tension between transparency and fairness really comes into play, because on one hand, people want to know what powerful figures like Trump might have done or known about Epstein's activities. But on the other hand, releasing unverified allegations could amount to character assassination based on gossip and hearsay rather than proven facts. The legal back and forth over these documents has been going on for months, with multiple motions, hearings, and appeals. And it's created this ongoing media spectacle where every court filing gets analyzed and speculated about. Even when the actual legal developments are pretty mundane, high-profile court denials and shifting strategies from Trump's team drive ongoing viral speculation and political tension about what remains hidden and what's actually been revealed in the sealed records. This creates a feedback loop where media coverage suggests there must be something explosive in the sealed files. Otherwise, why would everyone be fighting so hard over them? But the reality, based on what judges have said, is that the files mostly contain information we already have access to through other sources. Congressional oversight has added another layer to this whole situation because various committees want access to the files for their own investigations, and they have different legal authorities and standards than what applies in the criminal justice system. Congress can sometimes get access to materials that wouldn't be released to the general public, and they can also hold hearings, issue subpoenas, and create political pressure for transparency, even when courts are saying the legal standards for public release aren't met. So you have this multi-front battle happening simultaneously in the courts, in Congress, and in the media, and each arena has its own rules and dynamics. And it all gets really confusing for people trying to follow along and understand what's actually happening versus what's just speculation and spin. The reality is that calls for selective transparency are going to keep this fight in the headlines for the foreseeable future. Even as courts continue to block the actual unsealing of most materials, politicians on both sides see political advantage in either demanding full transparency or defending privacy protections, depending on which position serves their interest better. Media outlets love this story because anything involving Trump and Epstein generates massive clicks and views, even when the actual legal developments are pretty boring. And the public remains genuinely curious about what powerful people might have known or done related to Epstein's horrific crimes. So we're stuck in this situation where the legal reality, which is that most of the sealed testimony isn't going to be released and wouldn't reveal much if it was, gets overshadowed by endless speculation and misleading headlines. Let's break down what this all actually means for Trump's legal and political situation moving forward, because that's what people really want to understand when they see headlines about sealed testimony being exposed or revealed. The honest answer is that this particular issue around the Epstein files is probably not going to have major legal consequences for Trump in terms of criminal charges or civil liability. The judges have made pretty clear that there's no smoking gun in these materials that would suddenly change Trump's legal exposure. And the fact that his own administration has been pushing for selective release suggests they've done the analysis and determined the files aren't dangerous to him legally. That doesn't mean there's no political risk, because obviously any association with Epstein is toxic and creates opportunities for opponents to run attack ads and raise questions. But in terms of actual legal jeopardy, this doesn't appear to be a major threat. The bigger picture issue here is about transparency and accountability for powerful people, and whether the legal system is equipped to handle demands for information about public figures when that information is normally protected by secrecy rules. Grand jury secrecy made sense when it was created, and it still serves important purposes. But it wasn't designed for an era where social media and partisan media outlets can create massive public pressure for disclosure, and where anything involving famous people becomes a national obsession. Courts are trying to stick to traditional legal standards and principles, but they're operating in an environment where those standards don't necessarily match public expectations or the way information spreads in the digital age. That creates this tension where judges are doing what they think is legally correct by protecting grand jury secrecy, but a lot of people see it as a cover-up or special treatment for the powerful. The court rebukes for disingenuous reasons in seeking unsealing are interesting, because they suggest judges think the Trump administration is playing games with the legal process, rather than genuinely seeking transparency. When courts say that unsealing would only create the illusion of new disclosures, they're essentially calling out what they see as a publicity stunt, disguised as a legitimate legal motion. That's pretty harsh criticism from federal judges who usually try to be more neutral in their language. And it tells you they're frustrated with what they perceive as attempts to manipulate the system for political advantage rather than pursuing justice or genuine transparency. But at the same time, the judges are still following the law and denying the unsealing requests based on proper legal standards. So it's not like they're punishing Trump's team for perceived bad faith. They're just being more blunt than usual about their assessment of the motives involved. Congressional oversight is going to continue, regardless of what courts decide about public release, because Congress has its own constitutional authorities to investigate and demand information. Various committees are already looking into how the DOJ has handled Epstein-related files over multiple administrations, and whether there was any improper interference or cover-up attempts. This oversight function serves an important purpose in terms of holding the executive branch accountable, but it also creates opportunities for partisan grandstanding and selective leaks of information that serves one party's political interests. So we're likely to see ongoing hearings, document demands, and media coverage of congressional investigations, even as the courts keep most of the actual grand jury material sealed from public view. The media speculation around this issue is probably going to continue to outpace the actual legal developments, which is frustrating if you're someone who cares about accuracy and nuance. Every time there's a new court filing or hearing, we'll see headlines suggesting major revelations or bombshell testimony being released when the reality is usually much more boring and procedural. This creates a situation where public perception of Trump's legal troubles related to Epstein becomes disconnected from the actual facts because people are forming opinions based on sensationalized media coverage rather than careful reading of court documents and legal analysis. And once those perceptions are formed, they're really hard to change, even when subsequent reporting corrects the record or provides important context. For Trump personally, this whole situation is probably more of a political headache than a legal threat at this point. He has to deal with ongoing questions and innuendo about his relationship with Epstein, even though he's maintained he barely knew the guy and cut ties decades ago when he learned about inappropriate behavior. His opponents will continue to use any Epstein connection as a line of attack because it's politically effective, even if there's no evidence of criminal wrongdoing. And the media will keep covering every development in the ongoing legal battles because Trump and Epstein together is basically clickbait gold, regardless of whether the actual substance of the story justifies the attention it receives. That's just the reality of modern political media coverage, especially when it involves someone as polarizing as Trump. The legal precedents being set or reinforced through these court rulings are actually pretty important for how grand jury secrecy will be handled in future cases involving public figures. Courts are making clear that being a president or former president doesn't automatically mean normal secrecy rules don't apply, and that public curiosity or political controversy isn't enough by itself to override well-established legal protections. That's probably the right approach from a rule of law perspective, because you don't want different legal standards applying to different people based on their fame or political importance. But it's also a position that's going to continue generating criticism from people who think transparency and accountability for powerful figures should outweigh traditional secrecy protections, especially when the underlying conduct involves someone like Epstein, who committed such horrific crimes. The bottom line is that while no explosive new Trump testimony has been unsealed and court rulings continue to block disclosure, the public and Congress are going to remain focused on what's still hidden and the continuing legal maneuvering around these files. The story isn't going away, even though the actual legal substance is less dramatic than the headlines suggest. We're in this weird situation where the perception of scandal and cover-up persists, regardless of what the actual facts and court rulings say, because that perception has been created by months of speculative media coverage and partisan political attacks. And that perception becomes its own kind of reality in terms of how it affects public opinion and political dynamics, even if it's not grounded in what the legal evidence actually shows. That's the frustrating truth about modern political scandals. Facts and perception often diverge, and once perception is established, it's incredibly hard to change through mere factual correction. So expect this story to keep generating headlines and controversy, even as courts continue saying there's nothing explosive to release, and even as the legal battles grind on through predictable procedural steps that don't actually change the underlying situation in any meaningful way. The judicial system is doing its job by following established legal standards, but those standards were created for a different era and a different media environment. And until the law changes or some genuinely new evidence emerges, we're likely to remain in this holding pattern where the legal reality and the public perception remain frustratingly out of sync.